right. Let's see if we can begin the process. If at any point in time you're not hearing me, let me know, please. All right, so when we look at the elements and effects of will preparation, I'm saying that at the end of the session, you ought to be familiar with what are the laws that govern this whole thing called administration of estates. And that's when I talk about that, I mean whether you have a will or you don't have a will, what happens, what can you put in a will? Can you leave your assets to a pet? What happens if you leave me a yacht and after you die, I find out it have no yacht? What are something called what we call mutual wills? And of course, we'll come to your question, what happens if there is no will at all, right? And in treating with that, I will treat with what happens if you have no children, you're not unmarried, you have no children. We'll talk about that a little bit, right? So these are some, if you look at, take a note of the 7 points, what we ought to cover in this session. Some of the laws that you ought to know. And it's really, the laws are there for everyone. That's the website that I've put up. And these are the steps, right? So if you want to know what the wills and probate act says, you go to it and you go through. Some of it, you have the distribution of estates, the administration of estate act, whatnot. It might be a little more ticklish for you to navigate. So that sometimes you need to sit and chat with someone, right? Rather than trying to wade through a lot of that yourself. Put up the rest there, Succession Act, Wills and Probate Act, Administration of Estates Act, Trustee Ordinance. Those are the critical statutes that you ought to be, that you should be aware governs this whole thing about the administration of estates from the time a person dies to the distribution of their assets, right? I went forward a little too much because I wanted to know what was your understanding of a will. How many of you think that you have to go to an attorney to do a will? Anybody, tell me. Do you think you have to go to an attorney? Let me see any hands up.
Is it
You're not
necessary?
help me here. Anybody have the hand up?
I'm not sure if attorney is necessary to produce a will, but
who is talking with me?
Sorry, this is Marlon Pierre.
Yes, Marlon.
No, you had asked the question in regards to if it's necessary attorney to prepare a will. I'm wondering if, well, I suppose maybe based on your wording, because there are certain legal jargons.
No, and I want you to tell me yes or no. What are your thoughts? Do you think it's
in my opinion, I don't think an attorney is necessary to prepare the will, but I suppose with regards to
let me ask the question
filing it might be necessary. Sorry?
Let me ask the question another way. Is it a legal requirement?
I'm not sure.
You don't know. You're not sure.
No, I'm not sure of that.
Anybody else have any thoughts on it?
I do.
Nadia Sudan. Sorry.
This is Shakira. Oh, sorry, guys. Sorry. I don't know. Go ahead, or the person go ahead.
Go ahead. I will wait.
Oh, okay, no problem. So yes, I agree because having.
What are you agreeing with?
I'm agreeing with having a attorney because it helps a lot. It helps a lot. Yeah. So
okay, but that doesn't answer my question. Is it a legal requirement?
Yes, it is.
Okay, and why are you saying that?
Because there are illegal aspects within when you have to go through with certain things in the will that an attorney may have more knowledge of in terms of different aspects in figuring out certain things in the will. So I fully agree with in terms of having that.
Okay, let me hear the other person.
Hi, good afternoon, Nadia Sudan.
Yes, Nadia.
So I am, now that you asked the question, there are lots of questions in my mind, but I was of the view previously that an attorney did have to do it, and it is a legal requirement. But given that you've asked the question, I'm now unsure.
But I do understand that because I asked the question, you're not sure. All right, but let's see now. All right. So this essentially is what a will is. There are certain elements must be written. If it's not written, I know we haven't advanced to the stage where you leave something, a video and say, listen to me, you're my children, you know what it is I would have wanted. I want this one to have this, I want this one to have that. You'd have to go through quite a bit of hoop to get the court to recognize that. Our law says that it must be written, right? It's a written document. Now that document, bear in mind that the will does not take effect unless and until the person dies. The testator, that is the person who's writing the will, right? What we will say he has published his will or she has published a will, right? But it only takes effect upon the testator's death. Why is that? Because during the lifetime, a testator can change his or her mind as often as they wish, once they have the mental capacity to do so, right? So we know, okay, it has to be written. But when we're looking at a will, there are some issues. So, all right, you've decided I want to have a will done. If you come to me as an attorney, or you go to most other attorneys, there are some things that they would examine. What are some of the issues you think becomes critical? What should I look for? Hey, I tell you, I like to talk. I like people to talk back to me. And I see that we have more than 35 persons on the link, so I can get some responses. What are some of the things you should look for?
Maybe what assets are available?
No, we look at some of the issues.
Mr. Mullen said fraud document.
Court document.
Fraud documents. That's what Mr. Mullen Alexander would have said.
Okay. Who else? What else? What are you saying?
Beverly, Sherwin here.
Yeah.
I would say the person should have the mental and legal capacity to make a will.
Definitely. Definitely, because if someone comes to me and they're telling me that Hitler is coming to take over Trinidad, what do you think I do? That's a red flag, isn't it? Something not quite right. The elevator not reaching the top floor. Because if you're talking to me about Hitler in this day and age, coming to take over Trinidad, then something is not right. So there are things that you need to pay attention to.
Sorry.
Alison, go ahead.
What about if the person is under duress? I don't know if duress is the correct word, by someone else or someone is imposing on them to make a particular decision to will certain things to that second party or third party or whatever.
That's an important point. Undue influence is what we call it.
Can I ask if the person has to have proof of legal ownership of the things that they are trying to will?
No, you don't. If you bequeath in a house, I would generally ask to give me the deed, because I would use the schedule of the deed to describe the property, right? So that I am the owner of a house, a 2-bedroom house, located at so. It's not strictly necessary, but for certainty, I would ask for it, right? Describing deed number so. Yeah. But no, it's not imperative. It's not a legal requirement that you say, well, look, you say you have this amount of money in the bank, bring the bank statement and show me. No. You say you own the house, even if you don't bring it, it doesn't stop you.
I have a question.
Mhm.
So what if at the point in time that a will was made, someone had X number of assets. However, at the time of death, the number of assets may be decreased because there was sale of some of the assets and so on. How is that treated with?
Or COVID, we'll get to that.
Noted.
Right? We'll treat that a little later because COVID did that a lot. But this here, if you see the slide that is up, capacity or mental health. So if someone, I have a responsibility as an attorney. If you come to me to do a will and you are telling me you're hearing noises in your head or something that sends a red flag, then my next the next thing I do is say, well, okay, I need you to bring your doctor, a medical certificate from your doctor, certifying that you have the capacity to give those legal instructions. Right? Because remember, you're disposing of someone's asset potentially. So that if I hear something that triggers, or if someone tells me, I have 3 children and they have 10, that's a red flag. If it asks, well, what are your children's name? And you don't recall, that's a red flag. As a matter of course, if someone comes over the age of 70 to do a will, I ask, look, can you get a medical from your doctor stating that you have the capacity to do this, to give those instructions, to administer your affairs? Because if you don't, then it is a very solid ground for that being voided. So you may die and you may leave your yacht and your mansion to whoever, and another party comes and say no. At the time when this will was executed or when the instructions were given, the testator did not have the capacity to give those instructions. And if that is proven in court, then it is set aside. And that happens a lot in court. People, whether the person has capacity or not, there are some people who find you ain't leave nothing for me, or you ain't leave enough for me, and I would challenge it. Because you would have never, my mother would have never do that. My father would have never do that. I was the best child. They would have never write me out. You know, so that a little later on too, we look a bit at contestability of a will, right? When it could be contested. But capacity, mental health certainly is one of it. And this is what, when we talk about testamentary capacity, this is what we're referring to, the degree of understanding required by law of a person making a will, right? That is what is called testamentary capacity. Now, they must have that capacity when they give me the instructions, when they say, well, look, I want to do a will, and this is how I want to dispose of my asset. You sign those instructions, you go, I prepare the will. I say, okay, I'm ready for you to come to sign it. If at the time you come to execute the will, let's say you have been in a terrible vehicular accident, or there has been some rapid deterioration caused by some illness or something, that you no longer demonstrate that capacity, then there is no signing, no executing of that will. It's not valid. Or it is one that could be easily challenged. Yeah? Somebody was going to ask me something just now.
Yes, Ms. Samuel, good afternoon. Christiana Wallace. In a case like that, then the testator's signature can be fudged.
The testator's signature?
Yes.
Well, girl, unfortunately, that happens a lot. No, they don't lack testamentary capacity for that to happen. No, that unfortunately happens quite a lot. And it is a grounds for challenging a will if someone's signature is forged because it does not conform to the requirements of the Wills Act. To come back to my first question.
Thank you.
Anyway, I'll come back to it shortly. Let me just finish the section here. The testator must understand the nature of the act and its effects. If you're preparing a will, and the testator say, okay, when I die, I want this to go to X and this to go to Y. And then later on, the testator is of the belief that immediately it becomes the beneficiary's own. Then there isn't an understanding of the act and its effect. It doesn't understand it. It is only upon his death that the person takes possession or become entitled to. Because always remember that you can change your will at any point in time during your lifetime once you have the mental capacity. So if someone says, well, that's his own now, or feels that if you sign the will, then it becomes theirs, then that is cause for you to pause, right? You must be able to understand what it is you own. Let me go by way of example. My mom in her later years had dementia. My brother died before her. He was unmarried, the person who asked the question, unmarried, no children. So according to the act, he had no will. So according to the act, his assets went to my mom, right, as the surviving parent. When you asked her, or you said, well, you know, this house is yours, she said, really? If you talk to her about money, is that so? There wasn't an understanding because there wasn't the capacity, the mental capacity to understand that. So at that point, you could not ask her to do a will, or you ought not to have asked her to do a will because she lacked the capacity. She could not appreciate the assets that had become hers. She couldn't appreciate that, yes, this is now mine, right? So those are some of the things that you have to look at. In looking at it, we talk about no disorder of the mind shall poison his affection, because if you can't think straight, if you cannot properly process what is yours and how you are able to exercise and decide who gets what or not get, then it would color what you do. You may become very dependent on somebody else. And so you may have a child that you trusted a lot, that you depended on a lot, you know, and you become dependent on that and you trust that and you make a decision that if had you been in your right mind, had you not been suffering from dementia, had there not been some disorder, you would not have made those decisions. Right? If you find that is happening, then we're saying there is no testamentary capacity. No will is to be done. You have to leave it to fall to intestacy rule. So these are some of the things you must understand. I said it before, that he or she will die, that the will only comes into operation upon his death, that you can change or revoke the will at any time, as long as they have testamentary capacity. They must know who the executor is, and I know we have a question with respect to that. We'll get to the role of the executor, the powers of the executor, we'll touch on it. They must understand who gets what under the will, whether the gift is absolute or conditional, and by that I mean, whether you're saying, okay, I leave $300,000 to my niece on the condition that she obtains a degree in engineering or becomes a pilot by age so. That's a conditional gift, right? If she does not achieve that by a certain age, then it falls to the residue of the estate, right? In other words, she doesn't get it. So you want to know, is it absolute? I say I leave $300,000 to my niece. for absolute use and benefit. That's it. No condition. Right? They must understand that somebody you have earmarked as a beneficiary might predecease you. What happens then? Have you made provision for that in a will? A well-structured will would have what we call a residual clause, so that in the event a gift fails, that's what we would call it, what happens when it goes into residue back to the estate, because it bounces back to the estate for distribution. Right? The person with the testator must know, well, look, you know, I did a will in 1985 and it contained X, Y, and Z, but now, or in fact, I don't have to go back as far as 1985. I did a will in 2019. And at that time, I had 3 cars. I had a business generating income of 300,000 a month. And then COVID came. And by the time the country was reopened, I didn't have a boat again. So a person must be able to understand that the assets may change. Your old well may have had X, but you're doing a new one now because, you know, and you will be able to tell me how it differs from the previous will. If you don't recall that you had a will, red flag. Something is wrong. All right? Let me go back a bit and just talk about the executor. There are some people that think naming 4 executors, which is the maximum you can name, you know, will provide some kind of safety net. Let me suggest to you that that may also provide quite a bit of confusion, especially when you have to do probate. And we have a system where you can get a query every month on an application that you have made. If you have 4 executors named, then every query you get, all 4 have to be able to sign the supplemental affidavit. Right? So sometimes it becomes a little cumbersome. And I don't find it advisable to put that many persons as executors. To have to brings its own challenges at times, right? Much more for 4. When you're choosing an executor, remember that an executor stands in the shoes of the deceased, right? So in other words, you dare to do as if it was the deceased doing it. So it might be advisable in choosing the executor to make sure it's somebody who perhaps share the same kind of principles that you share, that you're sure would carry out the wishes in the way that you need for it to be carried out. Yeah, talk a bit more about executors a little later. I'm hearing a question. Did I hear a comment or a question? No. Right. Sometimes, and this is a particularly important one, in terms of understanding the extent of the property the testator owns solely, as opposed to joint ownership. If you have property, there's a phrase that very often persons don't look at in deeds. It is conveyed to X and Y as tenants in common, or it's conveyed to X and Y as joint tenants. If your deed specifies that the property is conveyed to you jointly with another one, joint tenants, then upon one party's passing, it automatically goes to the other party. If you put in your will that I leave my share of the property to X, that fails. Because when it comes to property, it cannot be passed. The joint tenancy cannot be severed by a will. Right? There are other ways that you can sever the joint tenancy, but it cannot be done by will. If you have a joint account in the bank, it passes to the other joint holder. So those are things that you need to know. I know some people use it in a way where they say, okay, this is my only son, and I don't want him to have to go through all of that probate. So they may say, okay, in your lifetime, you do a deed of gift from yourself and to your son as joint tenants, so that if you die, it automatically passes to him. If he
I have a
dies, then it comes
question.
right back to you, and you don't have to treat with how you do it. But I will take the opportunity to tell you, it's off topic, but when it comes to joint tenancy, a joint tenant may go and mortgage his share and interest in the property, and that effectively severs it, and it then becomes joint tenants in common. All right?
Miss Samuel, I have a question on this.
Sure.
So, you're saying if it's owned by two persons, you cannot leave your part of the
What's the
property in
key
a
word?
will.
What's the key term she's missing there?
Joint tenant.
Repeat?
Huh?
No, she could repeat again the question.
I was asking if it's owned by two persons, then she's saying that it cannot be automatically passed via a will to one person's successor, at least that portion. So it
Well,
only, I'm just confirming as to what I understand you would have just said.
Well, it's based on the type, whether it's joint tenancy or tenancy in common.
Right, so
Same two persons with different types.
let's say joint tenancy, as in, sometimes a family member might leave it to, let's say a mother leave it to a brother and a sister, her two children. And one of those children would like to leave it to their successor. You're saying that it cannot be left in a will. It has to be done while the person is alive, correct? Is it that I understand from this?
Is that what I said?
I think
No,
with regard-
that's not what I said. I said the joint tenancy cannot be severed in a will. You sever
Okay.
joint tenancy either by a deed of severance, it can be severed by a mortgaging of your share and interest, any of those kind of writing, right? But not a will. It does not conform to the provisions of the survivorship principle in a joint tenancy. So if you know you want your son to leave your share and interest. I was dealing with a client some time ago that inherited property as joint tenants with two of her other children. She has a son. The other two sisters don't have children. The property was mortgaged, but it required then, because it was a mortgage facility involved, that the mortgagee required the other two parties to sign off on it. They refused to. They say, no, we're not agreeing to a severance. But they don't have to agree to a severance. She could have proceeded to do a deed of gift of her share and interest from herself to herself and her son, so that effectively severed it. Or if she had gone and gotten an individual mortgage of her share and interest, that would have effectively severed it. So they then held as her share as tenant in common. The other two who didn't sever remained as joint tenants. So her share as tenant in common, you could put that in a will to go to whoever you want. But if you remain holding property as joint tenants with other persons, you cannot put that in a will. Or let me put it this way, even if you put it in a will, it will fail. It can have no effect once it's held as joint tenants. The survivorship principle in that kind of tenancy supersedes what you could possibly have put in a will. Did I make that any clearer?
So, hi, Ms.
Yes,
Samuel.
yes, you did.
Yeah. One quick one, Ms. Samuel Marlin here. So you're saying with regards to in tenants, joint tenancy, that if one of the parties would like to leave their share to whether it's son, daughter, but whoever, to whom, they should prepare a deed of gift.
You
whereby
should
they-
sever first, however you sever. There are several ways of severing.
whether mortgagee or, okay,
Deed of severance, whatnot. And then a
okay.
deed of gift is one way of severing. Mortgage is one way of severing. A deed of severance is one way of severing.
Is it that you need a lawyer to do a deed of gift?
Once you talk about a deed, you need a lawyer.
Okay.
quite
How does it-
unlike preparing a will. The
How does
act
a deed of
doesn't
severance
require that a lawyer
operate?
prepares a will. It might be advisable to go to an attorney, but it's not required by law.
Ms. Samuel, how do you what deed of severance? How does that work?
Miss Duncan, I think we've gone into land.
Oh,
Wrong session. I
That session
understand
is coming up.
your interest, but let's reserve it.
no
Let the
problem.
education committee deal with that separately so that we keep focus on what we set out here today. All right. Let me go on a bit. We look at the formalities. So this is the will. We're looking at formalities, we're looking at gifts, we're looking at revocation. So this is what is required. To make sure the will is valid, it must be in writing. It must be signed by the testator or by some other person in his presence and by his direction. So let's get the testator to sign, because they're going to say the testator never tell them that, right? So it's written, the testator signs. The testator understood what he was signing, it is clear, and that comes out in the jurat, what we call the jurat. So you know that it was signed by the testator, who understood whatever. And the signature is made in the presence of 2 or more witnesses at the same time. There is nothing there that says it has to be in an attorney's office. How many of you believe you have to lodge the will in the Red House? Anybody?
Yeah, I think so.
Okay. Who believe that you have to have a stamp on it?
That's interesting.
You believe so? I see somebody nodding their head. Neither
I
is the
think to
case.
avoid contested, I guess it's
How
recommended.
that's stopping me from contesting a will?
Well, it have somebody else that say that this is the person that issued the will and would have agreed to the terms and conditions in it.
Well, that ain't gonna stop them. You have 2 witnesses that when it reach your court, the witness better reach your court and state, yes, I was present. If the person is elderly, it would be helpful to have had the medical report to say, look, I did so. And this is the case, you know, the doctor tests that they had the capacity to do the will, right? So there are certain safeguards that are put in place. But it's not necessary. You can keep your will below your mattress. You can give a good friend your will. You can give it to the executor. You could have it in your briefcase or your suitcase. It doesn't have to, and there's no requirement for it to have a stamp of any sort on it. There is provision that you can lodge your will at the probate section in the Hall of Justice. Right? But that have nothing to do with the Red House, which are common answers. It have nothing to do with a stamp. It have nothing to do with an attorney thing to make it valid. It may help your case if an attorney would say to the court that I saw the person and they were by themselves. There was, if you come to do a will, whether you come with your auntie, nana, brother, sister, I only want to see you because I have to satisfy myself as an officer of the court that you are not being unduly influenced, right? And that becomes critical, especially when persons want to contest the will. Who can sign the will? Do you think, who ought not to sign a will? Let me ask that instead.
A minor.
A minor, correct? Well,
Perhaps one of the beneficiaries?
correct. Very correct. Can an executor sign the will?
No.
Why not?
Would that be
Because
conflict of interest?
perhaps they might also be a beneficiary in some cases.
Well, okay, so we say a beneficiary can't sign. Why an executor cannot sign?
Would that not be a conflict of interest if the executor have to be acting on behalf of the testator?
Why is that a conflict of interest?
in the context of, I mean, I'm looking at it as if I'm going to be acting on your behalf, it should be, I shouldn't be, even though you're signing me as a person acting on your behalf, I don't think it, whereby,
As long as the executor is not a beneficiary, there is nothing preventing him from witnessing the will.
oh, okay,
If you're a beneficiary, that's where a conflict comes, because A, I am signing, making sure, look, you give me what I want.
similar to signing a check that is in your name.
Right.
Understood.
What's wrong?
Now, a well-drafted will, I'm going to the second point here, should contain an attestation clause indicating that it was executed in accordance with the requirements of the Wills Act. So it naturally raises a presumption in court of due execution. I have followed. So it reads something like this: signed by the testator in our joint presence, and then by us in his. Right? Of course, if the testator is blind or by reason of some sort of illness or is illiterate that they cannot sign, you may use a thumbprint. Very often, what would happen, and whenever this occurs, I prefer to use a commissioner of affidavit as a witness. So you take the person into the room and you read over the will to them and ensure that they understand and confirm that, yes, this is what you wanted. So then the clause says that you help him. I read it over to him and he appeared to understand, and I help him to affix his right-hand thumbprint on the document as a signature. Right? So it is a safeguard because there is recognition. Not everybody would be able to sign, but a thumbprint is used, and where you have to use a thumbprint, then you have an independent person who confirms that, yes, this is what they wanted in the first place. I have read it over to them. There is nothing in it that they objected to. And I held them to fix their thumbprint as their signature. I see a question on her face. Shakia. Question?
No, Ms. Bobby, it's Shashia, but no.
Just share. Thank you.
Yeah, no problem.
Okay.
Hi, good night.
What?
Oh.
Go ahead.
I just have one
Somebody
question.
asking something?
Yes, you hear me?
Mm-hmm.
Hi.
Tell me
Right.
who you are, though.
My name is Avian.
Yes,
So
Avi.
in the instance, let's just say if the person lives on state land, can they will that land or the property to anybody else?
But that dying them on? Or you're giving away something that is yours? What you can do is to will the chattel. That is the house that you built on it. That's yours. Right? If you have, let's say, for instance, you want the land for 60 years. You say, okay, you may have developer share an interest in the land. Or if you were renting the land, that you may pass that to the person. But you can't say, I will, that is like saying I will move it on to somebody in her mind. Follow?
Yes.
Hi, good night. I have a question.
Tell me your name.
My name is Tambi Serrano Rock.
Mhm.
So my question is, somebody was granted permission to live on a piece of land, and they were also granted permission to build a house on the land, right? That person was not paid any rent or anything like that. They were granted permission. That person came and died. He had a common law spouse. That common law spouse has now done a will for the house on the land that is not theirs. How does the person who owns the land treat with that?
Well, that's up to them whether they want to say, well, look, let us enter an agreement that we sell you the land. Because if there was an arrangement, and I would hope they had it in writing, that the person had a license to occupy the land and permission to build on it, I was not taking permission to build on land that I don't own or had no promise of it becoming mine, because it's not very easy to lift up the house and go, right? So that you could will the chattel. But I don't see how you're getting past a licensed occupier to take the land. Sometime recently, you might have seen something in the news about a woman whose house was demolished and her 7 children, and she was left stranded. And the media was blazing the judge in the matter. And I'd be interested to see what actually was put into court, because it may well have been that they had been given permission. And when they say, well, okay, because a license is something that is revocable. If you revoke your license, then you went into that, you agreed to that. There's a difference if you say, let's say somebody says, look, I am giving you this. I am telling you, you go ahead and build. This is for you and your family. They say, well, here I see you and your family. That's a promise. And the promise would entail you building on the land and occupying the land, even if it is a life interest, you know. So that's a different thing to saying, I am letting you occupy for, let's say, a finite period, a certain period of time, right? It doesn't give you the rights then to pass on that permission. That permission is not transferable. Yeah?
Okay, so then the chattel owner now has a problem.
Which we wouldn't deal with in this session.
No, I was just confirming the chattel owner now has a problem, correct?
I would think so, yes.
Okay, all right, thank you.
But these are some of the things that you can include in a will. Property, investment instruments, memorabilia. All right, so the Calypsonians, and they may have some of the props and things that they use, and they want that preserved. They may say, okay, start a museum, put this here, or there are some things that, you know, valuable. They may have old coins, people may have different things that you have, that you can put those things in a will, right? What happens if a gift does not exist? Can a gift be purchased from a specific account? Any thoughts on that? No takers. So I may write a will, a bequest in 2 ways. One, I may say, I leave to Nadia my gold watch. Or I may say, I instruct my executor to use money from X account and purchase a gold watch for Nadia. All right? So one, if you leave a watch for her and you die and there's no watch, there was no provision for her to get the watch otherwise, then the gift fails. What we would have called, or they may have had it at one point in time and then it got destroyed. So we may say that these, the same thing, it's no longer there. You can't give her what it do exist, right? And since there was no authorization to purchase it from an account, from monies that you have, there's no gold, no watch to be given. If, however, you authorize that, right? Or you may say, so sometimes people may put some things in a will a little too specific. So you may say, I leave my Mercedes-Benz registration number, so to this person. And at the time of the death, that particular vehicle no longer exists. You may have changed your vehicle. But if you put it that at the time of my death, I leave any vehicle that I may own to X, Y, and Z, then it covers whatever vehicle you have currently. If, of course, you have 3, 4 vehicles, then you may want to put, you know, make it a little more. You may not want to leave it all for one person, right? So you distribute accordingly. What happened? Tell me what happened if I leave my watch to Nadia and Nadia say, I don't want it? What do you think happened instead?
Would that roll back into the estate?
Correct. Very correct. It lapses, what we call it, lapses into residue. Right? What happened if there's an asset that was not dealt with at all? Might have had $1 million National Lottery Board owed you $1 million and you didn't remember that. Don't ask me how, but you didn't remember that. What happens said? So it's not specifically disposed of.
Is it now that they have to file for letters of administration for the residual assets?
Not necessarily. No, you don't. You're dealing with the probate of a will. So we say the distribution then is according to the intestacy rules. So you have your will. It deals with everything except this $1 million, or the watch comes in, or a car comes in because it was not specifically disposed of. Then the rest of it, if you have a residual clause and you say all the residue of my estate, I leave for X, Y, and Z, then everything else that was not specifically disposed of goes to X, Y, and Z. If you do not have a residuary clause, then the intestacy rule kicks in and you distribute it according to the law, and we'll get to that. Yeah? This is what we refer to as the residuary clause. The remainder of assets, after all, just debts and expenses have been paid, right? So whatever remaining, if you say, all right, give that to Maria, fine. If Maria says, I don't want it, then you say, okay, let's see what the law says about, you know, the intestacy, where it's not specifically disposed of, how we distribute. Question. Does marriage void a will? I've done a will, and then a few months after, a couple of years after I get married, is the will still effective? Don't rush, tell me.
Yes.
Yes, it's still effective. Why you say that?
Because that would have been assets attained before the marriage.
Mm-hmm.
So those things would still be valid, and things I'm assuming after the marriage will now be for the spouse, or the spouse can challenge those things after the marriage.
So you're saying that the will would no longer be valid?
No, I'm saying the will will still be valid because it would have been done before the marriage. And that would have been assets you would have had before you got married. But any assets after the marriage will, well, a new will or, okay.
I got you. I see somebody has a hand raised. I'm just seeing the phone type, so I don't know who it is. Samsung.
So but the will still be valid, but isn't it now mandatory that you make a new will to include your spouse?
But if you tell me the will valid, why it would be mandatory to make a new?
But suppose that my spouse wouldn't get anything because she wasn't in the picture before.
Okay. Anybody else? Anybody disagrees with that position? Anybody feels
I
it would
disagree.
not be valid?
I disagree, because then why do persons need prenups? I think once you are married.
We don't have prenup here.
Okay, well, but I think it would be null and void once it is you get married.
Why?
Because now you enter into an agreement where what is yours is your spouse's. So you can't give away something that don't belong to you alone. So now
You
it's
already
half
gave
the
it
woman
away,
or the
so
man own,
supposedly.
so you can't give it away yet.
All right. So this is what we say. You have an old will, you get married. Generally, and take note, I say generally, a new will is required. If, however, you know you're going to get married. Let's say that you're going to get married to John Doe, and you do a will in contemplation of marriage to John Doe, then you would have already taken into account the new relationship. Once you do your will in contemplation of marriage to a specific person. It can't be that, look, I'm doing this will in contemplation of marriage, and you don't know if and when you're getting married or who you're getting married to. So if the old will, I'm doing this will in contemplation of marriage to Snuffleupagus. All I know, Big Will talk about Snuffleupagus for the longest while, and none of we could have seen Snuffy on Sesame Street, right? So you don't want to do that. You want to do the will in contemplation of the person you know you're getting married to, this person, that will hold. If you don't have a specific person that you intend to get married to, and eventually marry, you have an old will, you get married, then please invite your attorney to your wedding. And after you have signed the documents, he should have the will there. When you're going down the aisles, execute with the witnesses now. So you have a new will after the marriage, because a new will be required. Revocation. Can you change the will once it's done? I think we have spoken about that. I talked about that quite a bit. Yes.
Yes, you can.
And change your will. And I just want to run through some common mistakes. The will was incorrectly witnessed. So you may have a will with one witness. It will not stand. That does not satisfy the requirements of the Wills Act. Asking a child or a partner to be a witness, that's a no-no. In other words, make sure the witnesses have no potential to gain anything from the will. So if your executor is a beneficiary, that's a no-no. Cannot sign as a witness. You could be an executor and a beneficiary, but you cannot be a witness. Having an out-of-date will. We know a lot of our assets change after COVID. It is a good time to review. If you have had a will done, it's a good time to review it. Now, your assets could either increase or decrease. So for some of us, if we were in the pharmaceutical industry, your assets may have increased considerably after COVID, right? Because there was such a high demand for that kind of service and whatnot. Or some of us, there are some people who may have lost their homes because they lost their job. There are consequences to, consequential things that occurred during COVID and afterwards. So that you have to ensure that you have an up-to-date will. When you have an up-to-date will, you reduce the level of confusion afterwards. Making changes, say, well, after it has been signed, it's not simple to say, well, okay, you just write a note on the existing will. You either make a codicil or alternatively make a new will altogether. Out of abundance of caution, I always recommend just do a will. Yeah.
Okay.
Forgetting assets. So you're thinking of doing a will. Take some time to sit down and make a list of all the things that you have. Ginkgo don't always work. I tell you need some ginkgo, you need some this. Write it down. That way, so get a note of, you take a note of your bank accounts, numbers, your credit union, shares, what they have, whatnot. As I am saying that, there's one thing that I wanted to point out to draw your attention to is credit union. The Credit Union, the Cooperative Society Act provides, I'm sure you know the clause that speaks about the payment of up to $50,000 now to the beneficiary on your account. Yeah? Yeah? We know that?
Yeah.
Right. Look at the clause carefully. Very often, we assume that if we have a beneficiary name on the account, that whatever shares we have, whatever assets or any credit union, that it would go to them. That is not the case. The law is very specific. You pay up to 50,000, and after that it goes to the estate. So if your intention is that the person who you have listed as your beneficiary on a credit union account, that they inherit everything, then put that in your will, please. Yeah?
Okay.
Take a note of that. The other thing, sometimes persons with minors, they fail to appoint guardian. So you may have an executor, but you did not appoint a guardian. So let's say the parents die, and especially if you are the only surviving parent, if you then leave it, if you don't put something in your will with respect to guardianship of the minors, then you leave it up to the court to make that decision. And sometimes they don't quite go the way that you wanted to, right? Or you would have liked. Somebody's hand is raised again.
Can you please just go over the portion with the 50,000 goes to the beneficiary from the credit union and the balance? Could you just explain that again?
Okay, the law says they can pay up to 50,000 without a grant, without applying for letters of administration. But the assumption is that persons think after getting letters of administration, the rest goes to the beneficiary. But that is not what the Act says. The Act says that the rest goes to the estate of the deceased for distribution, right? So it doesn't go to the beneficiary. So I'm saying that if your intent is that the named beneficiary inherit all that you have in the credit union, then make provision for that in your will. That I have X amount of shares in the credit union and I leave it too. So there's no doubt. Otherwise, it will fall into intestacy. You good with that? You understand?
Yes, thank you.
All right. So as I said with the guardianship, make sure you address that. More common as mistakes, you exclude step-children. Sometimes you may say, I leave my children in the will, and the court, we say in court and family division, that if you have been taking care of somebody for X number of years, they consider the child of the family. So that the term, my children there may be a little vague and lead to confusion because it doesn't they're not automatically covered. You know, make sure that you state it explicitly in your will. We talked before about not being too specific. I've given an example there. If you leave one of your children the black BMW, but you need to sell this car, whatnot, right? General description, the car that is in my name at the time of my death, etc. We've been through that. Forgetting to name an executor, appointing inappropriate executors, and I spoke about that. Be careful in terms of choosing your executor, and make sure at least somebody knows where the original copy of your will is. If you really think you don't want to tell anybody, you don't want anybody to know what you've written in your will, then lodge it in the probate section in the whole of justice. Because automatically when you're applying, you have to do a search, and the search would indicate, you would see at the end of the search report, the attorney, when they do the search, at the end of the search report, you would see either no will lodge, no application made. If there's a will lodge, it would pull it up and it would say will lodge on such and such a date. So then you extract that will and probate the will. Yeah? Capacity and not accounting for debts. So sometimes we leave things to beneficiary and we leave them with some debt, and a lot of times people refuse a gift because coming with it is a kind of burden that they are unable to take. Yeah?
Mhm.
Do it yourself will, even though it's not a legal requirement that you go to an attorney. If you know that there are certain complexities that you have, you know, the kind of assets, and a lot of time business people have more complex assets. If your will is not a simple one, if you want to deal with guardianship, you have minors involved or whatnot, my advice is that you go to an attorney so that you avoid some of those errors. And the biggest mistake of all is deciding I don't need a will. If you die without a will, we say you died intestate. You die with a will, you die testate. Without a will, it is intestate. All right, and we'll go through. Talk about changing the will. If I file a will in court and there are burnt edges, I have to account to the court as to why the will is in that condition. Is it that the person tried to destroy it? Did they change their mind? And you grab it out before it could get fully burnt. If it's torn, did they try to tear it up and somebody prevented them? You have to account for certain things, right? So that you can change a will by, I could do a will for you and you walk out my office and you tear it up. You don't want that to change your mind, right? If you write a will a little later on, then it invalidates the first will that is done. Or you can do a codicil to attach to an existing will.
Hello, good night.
Mm-hmm. Alison?
Annalisa. Yeah, Annalisa here.
Yes,
Asking
Annalisa.
a question. It was in the slide before, and I don't know if it's a myth or something in North America, that you could do a will, write your own will, and if you mail it to yourself with a what? A government, you know, like you mail it to yourself, TT Post. What is that?
What is that?
Yeah, what is that something that is a will? Is that a legal document? No, it's not. So it's not legal then. Fine. Thank you.
But all that what I went through, what is required to satisfy the Wills Act, what makes a will valid? Written, signed by the testator, witnessed by two persons. So it's signed by the testator in the presence of two witnesses who signs as well. Right? Those are the basic requirements of a will to conform to our laws. Right? Whether you post it, you put it under your mattress, you lodge it with probate section. Once it conforms, then it's valid. Yeah? Mutual wills. Now, this is something that you may find that couples do. Right? Now, remember I spoke about you cannot sever joint tenancy by a will. Right? So generally you don't distribute your property by a will if it's held as joint tenant. And anybody ever heard this term, mutual wills? Yeah? No?
No. I'm not familiar with it.
All right. So when we talk about mutual wills, two things. So a husband and a wife do a will that mirrors each other. So you say, so we have agreed, all right, I own this house and we own this house in Twin City. And you say, you know, whenever we die, this house, we agree that this house is for this child. All right? The fact is that if I die first, the other party could do what they want. They could change the will. So even though they do a will that mirrors each other, what really stops them from changing that bequest is a back agreement. So you have a deed of agreement where you state that it's executed contemporaneously with the wills that the parties have been agreed that upon their death, this is what the disposition of this particular asset, right? So you do it in the form of a deed and you register it with legal affairs. So if party A dies and party B remarries, that agreement there says the bequest. So that they can't change that. You can change anything else in the will, but that what we have agreed to, and we have reduced into an agreement that is registered with legal affairs, into a deed of agreement, that cannot change. Follow? So that the will mirrors each other generally, but you have agreed, look, this is what we will do with this asset, and we do a separate agreement that is registered with legal affairs. That's a deed of agreement. So even if the surviving party attempts to change it, there is that agreement that the beneficiary can pull out and say, no, you cannot otherwise dispose of this asset. This is what they agreed to. Yeah? Questions? No questions on that. We understand that. We come to probate in the will. Let's see how much more time we have. Half hour. Grant of probate, letters of administration with will annex if you have no executor. So you have a will where you have an executor name, you apply for a grant of probate. Where you have no executor name, it is letters of administration with will annex. Let's say you get the grant, but the executor dies or the legal personal representative at that point, you call them, dies before they have a chance to transfer the assets. Then you have to go back to court for a new grant. So we say you're going back the bonus none. The bonus none meaning that they would have died, they've gotten the grant, but died without having distributed the estate, right? Where you have a grant obtained in another jurisdiction, they do it for the states as well as the Commonwealth country. You take that and you apply here to reseal that grant to allow you to deal with assets that the deceased may have in Trinidad and Tobago. We don't have time for you to take a break, so you just take it in your head for a little 2 seconds there. I'll take 2 questions before I move on. Tell me anything, any comments?
Hi, I'm Samuel Malanpia here. With regards to earlier with the mutual wills, you were saying that both the husband and the wife have they have mirrored wills, so to speak. The same, it's 2 separate wills, right? That each of them have.
Yes.
Right. But there's a specific item in each will where they say this is supposedly going to our son. So irrespective of whatever happens, that deed of agreement protects that item on their will.
Yes.
Okay,
yes.
Understood. Thanks.
Where affidavit of alias, we have home name and the real name on the birth paper. So you may end up with some documents with different name or different spelling of names. Then you find that you have to go on affidavit to say this person has been known as so from birth. It was called so. This name was spelled so, but in error it was put on as this. So you go on and you account for every variation of the name that may exist. That's a standard thing that will come up where they have that. Affidavit of law, that really has to do with if you're resealing a grant, then, or if you have no grant obtained, then an attorney abroad has to go on affidavit to state, look, there was no grant given in this country, whatnot, and to allow them to proceed in Trinidad. To go a little faster here, we're coming down to the end, the end of the time of the slides. The executor, KSUs, know who you're choosing as an executor, know their responsibilities and challenges, renunciation, the executor as a fiduciary. So any of these could be an executor. If I named Jane as an executor of my will. Jane, in turn, has a will in which she names John as an executor. If Jane dies before completing the probate of my will, then John, who is her executor, becomes the executor for her will and my will. And therein, I always point out, lies the importance of you knowing who you appoint as executor of the estate. Because you may be happy with Jane, but you know Jane associates with John, and you're not happy with how John conducts himself. But bear in mind that there is the potential that John could end up being the executor of your estate because of the chain of executorship. That chain is only broken if the next person dies without having published a will or having named an executor. But once if the executor of an executor becomes the executor of your estate. So that chain continues unless broken otherwise. Yeah? Responsibilities of the executor is there. Reasonable and prudent management. Keep proper accounting. Important, distribute the estate according to the wishes of the testator. The executors have a legal obligation to follow the testator's wishes as closely as possible and distribute the estate according to the will. The executor does not have the right to say, he should not do this now, how we could cut out this one, I'm going to change that. No, you have to follow. You're sitting in the shoes of the deceased. So whatever the deceased wish is what you have to follow through on. If an executor fails to follow what is set down by the estate or deprive a beneficiary of something or fail to probate the will, the beneficiary could call the executor to account. And by that I mean they can file an application in court to compel the executor to act or have him removed as executor and allow someone else to apply for the grant for the estate. And with the executor, if you're doing it when you appoint an executor, look at things like, especially again for people who are business people, whether the executor is entitled to hire a professional to treat with certain parts of the assets, right? So that you can pay for certain services. Whether you want to say, well, you know, the executor is to be paid X amount of money for the services that he is providing, that kind of thing, but there must be that particular entitlement. They can't assume that if it's not stated in the will.
Hi, I have a question, please. So my question is, if there was a will, on the will there, the executor is also one of the beneficiaries. There are 3 beneficiaries in total. The executor did not execute because let's say it was to give the 3 persons 3 parcel of property and nobody got anything. So the executor is still holding on to all the properties.
So the executor applied to the court for the grant of probate.
Correct.
They got it, they got the grant.
Got it, yes.
And refused to distribute.
Correct. The executor now goes on to make a will, making somebody an executor to their will. What happens to the other parties in the first will? How do they deal with that?
And that is why I talk about calling the executor to account, to go to court.
Okay.
To compel the executor to distribute. Because the executor has no legal authority to keep the property as is. Sometimes it is that persons have not done what we call a deed of assent for the simple reason that there may not be money in the estate to pay for the services, and the beneficiaries have refused to bear that cost. I think they can reasonably ask the beneficiaries to bear the cost if they are not able to pay for it, to deduct it from proceeds from the deceased estate, right? But sometimes people just on a high of their own, you know, you have power. And the power is mine, whether I transfer the property to you or not. And that's not the case. That's why you always have recourse to the court.
Okay, thank you.
Right, so renunciation, a person named as an executor can choose, look, I don't want to get involved in this. So they do the renunciation, and there's a format that we use. So they sign as renounce and probate. And he can do, but he could change back his mind up until the time when the application is filed. Once the application is filed, whatever goes in, right? Now, the executor cannot renounce in part. He can't say, look, I will deal with this set of assets, but I'm not dealing with them, and that's it. So he can also renounce as an executor, but still act as a trustee, so that if the will speaks about this one being trustee as distinct from somebody being executor, then he can still do that if he wishes. How is a will contested? What makes it contestable? I'll go through 742. I'm watching my time. Inadequate provision. Let's say, for instance, you were taking care of someone up to, let's say, the last 6 months of their life, and you leave nothing. They could contest on that basis that, you know, you had been taking care of them, so that there is a legitimate expectation that provision would have been made for you. Right? Undue influence, we talk about that. Someone early, they talk about duress, which I said is what we call undue influence. Somebody because you're dependent on them. Let's say you're hungry and they say, oh gosh, give me something. Me now, oh God, take it. Just I will give you everything. I can get something now. Or the person is ill and dependent on you for care. And you use that kind of influence to, you know, force a particular outcome in terms of a will. Or if there is incapacity, not signed by two persons, not executed in accordance with the Wills Act. Those are grounds on which a will could be challenged. There's no guarantee that it would be successful, but those are grounds on which wills can be challenged. Who, what, how? So these are the persons that could challenge a spouse or cohabitant of the deceased. Any person who is being maintained wholly or partly by the deceased, former spouse of the deceased who has not remarried, child of the deceased, or child of the family. So a stepchild, which would fall in the category of somebody, they may fall in the category of someone who is being maintained, can seek to file that application. Definition of maintain: if he is making a substantial contribution in money or money's worth towards the reasonable needs of that person, right? And the court can make one or more of these orders. Either continue payment, a periodical payment, let's say for a 5-year period, let's say the person was in school. If it's a handicapped person, the court may make a order that it may maintain for the rest of the natural life. You know, the court has quite a bit of discretion in terms of the order that it can be with respect to that. Make a note of this. If we do no will, then intestacy rule applies. And I can go through this fairly quickly. If you die leaving a spouse and children, half of your estate goes to the spouse. The other half is distributed equally among the children. And that's what is inside children or outside children. The children asked to come. All right, they are your children. You did not do a will. Half, yes, it goes to your spouse, the other half to your children. Hand raised. Let me hear.
Ms. Beverly, I just wanted to ask a question. If the spouse is divorced, yeah, and he has not done a will as yet, and he passes, forbid, what it would be for the person that he was married for, and then the children as well, in terms of kappa. Oh,
But that is not spouse, that is ex-spouse.
well, yes.
If
it's
you're
ex-spouse. I
divorced,
don't know
you're
if
treated
ex-spouse
as if you're dead.
Okay, so that doesn't apply. So it all goes to the
No,
half to
if
the end.
the former spouse who has not remarried thinks that they have valid grounds on which to challenge the will, they can do that. But in terms of intestacy, there's no provision for an ex-spouse. If you're not a current spouse of the deceased, there's no will, then
Okay.
it don't apply. But the next
Question, is it adult children or children under 18?
Doesn't
Everybody?
matter.
Doesn't matter.
Doesn't matter.
Okay.
All right. If you have no spouse, if you have no children, you're married or you're living with someone that qualifies as a cohabitant and that has its own application to go with, then it goes to that person absolutely. Once the cohabitant under our Cohabitational Relationship Act, they send a notice of notification of interest, they file that to the court within 28 days of the death, and they have to establish that they had been living together in this jurisdiction for 5 years or more, right? They'd have no issue of no children before, whatnot, to say, well, okay, whatever they own before you started to live together, you cannot claim that. It's just the cohabitant and him. There's some people who have lived together for 20, 25 years. Once they establish that cohabitational relationship exists, there are no children, or you're married, you have no children, then everything goes to you, even though there is no will. Intestacy rules continues where you are, I think blocking part of my presentation. The intestate dies, leaving spouse and cohabitee, which can happen very easily in Trinidad. Since we think a deputy is essential, you may be living with somebody, but you never formally divorce your wife. Then the cohabitee, once you establish again, it has been 5 years or more, you've been living together. But the only part of the estate that you can claim for is that which was acquired during the period of cohabitation, right? And you say, I have it here, file a notice of interest, within 28 days, you list your order, right? And you treat with it that way. You have spouse and cohabitee. Disregard this final part of the slide. Where you have no spouse, no cohabitant, you have children only, then all of it goes to the children. Inside and outside children. You have no children, no spouse, no cohabitant, then you go up to the parent. One parent alive, it goes to that surviving parent. If both are alive, then it's divided equally. If your parents are deceased, then the next point to go to is your brothers and sisters of the whole blood, and that is the only time the court makes a distinction. When you go across, you're going across to the persons who share the same mother and father with you. If none of that exists, then you have sister, half brother. They're the ones to inherit. If you can't find anybody there, then you go up one step further if you have grandparents alive. If you can't, then you come back down to your nieces and nephews of the whole blood, and if not, then of the half blood. Nothing there, you go up to uncles and aunts of the whole blood, and then of the half blood. Now, this is quite a bit of persons to go through, because if after all of that, you can't find somebody to inherit, then it goes to the Administrator General.